Hi, and welcome to session number 4, Informed Consent. Consent and informed consent may be used interchangeably by people, but there is a big difference between them in legal terms. So, in consent, a person has a right not to be touched without consent. That's basic consent. Informed consent, on the other hand, refers to a dentist's duty to inform patients of the risks, benefits, and alternatives associated with proposed treatment so the patient can make a meaningful choice about whether to go through with it. No consent is battery. Every human being of adult years and sound mind has a right to determine what shall be done with his own body, and a surgeon who performs an operation without his patient's consent commits an assault for which he is liable in damages. You'll notice that the date on this citation is 1914, so we know that the concept of patient autonomy has been around for a very long time. So why is battery such a big deal? Mostly because the damages arising from a battery cause of action generally are not covered by malpractice insurance. Of course, there are other big deals about batteries, but that's kind of a large thing to consider. Battery is an intentional tort, and most intentional torts are excluded in standard malpractice policy. If the cause of action for battery survives a summary judgment or dismissal, it will be fairly easy for the plaintiff to prove the case, because the plaintiff only has to show, 1, that there was no consent, and 2, that the touching occurred. No expert witnesses are required in a battery based on lack of consent. So the plaintiff can also seek damages for any harm that resulted from the medical treatment, not just that which would be considered negligent. For example, if there is no consent for a molar extraction, during the extraction, the patient suffers permanent nerve damage. However, the nerve damage was not the result of negligence. Because it was battery, the patient would be able to recover for the nerve damage. The patient can also recover punitive damages. Punitive damages are intended to punish the defendant. It's the way of the court sending a message. You'll want to note the South Carolina verdict that I have in Moodle for pulling patients' teeth without consent. It's a very good example of a punitive damages dental case. So real briefly, what happened is dentist 1 obtained consent to extract 3 teeth and make a partial upper denture. Dentist number 2 then came in and extracted all of the patient's upper teeth. He then altered the record to make it appear that the patient had consented to the more extensive extraction. There were also record alterations that tried to make it appear as though the patient had initially presented with fewer teeth. However, the x-rays taken at the patient's initial visit showed that she had more teeth. So dentist number 2 also tried to make an argument that a walk-in clinic owed the patient a lower duty of care than that which would have been required at a regular dental clinic. It was very interesting as I'm seeing that attitude in medical malpractice cases involving urgent care as well. It's a fallacy. In the future, if you ever feel like you should be able to offer care at a lower standard to your patients for some reason, call your malpractice insurer for confirmation. In this case, the jury simply didn't buy it, didn't like the self-serving record alterations, and probably didn't like the dentist's arrogance. The jury returned a $2 million verdict against dentist number 2 in the clinic. $1.5 million were for punitive damages. From a defense standpoint, this is a case that never should have gone to trial. So I'm assuming that the plaintiff was not willing to settle for the dentist's policy limits, which were probably $1 million. And that's why it went, because the plaintiff knew that they could get more than $1 million at trial. What is consent? All procedures require consent. You can't just grab a patient's arm and stick a needle in it when you need some blood. So you, as a dentist, are going to ask, I'm going to clean your teeth now, all right? And the patient has to say, okay, that's consent. Keep in mind here, informed consent requires more. We're just talking about consent. We'll get into informed consent in a minute. You may hear about implied consent. So there are limited circumstances in which consent is applied. In a blood drawing situation, the patient will frequently offer an arm, which under the circumstances implies consent to the blood draw. So you would think that opening one's mouth in response to a hygienist saying, "I'm going to clean your teeth now," would be adequate consent for dental treatment. But the Minnesota Dental Board doesn't think so. According to the Dental Board, no treatment can be given without express consent. Therefore, you need to get an express consent for everything that you do. If something has risks, then additionally go through the informed consent process. Emergencies and preserving life and health during surgery are also exceptions to this consent requirement, but those probably aren't going to arise in dentistry. However, if a patient is having an allergic reaction to latex, you do not need to have them sign a consent form to administer epinephrine to help save him or her from anaphylaxis and possible death. All right, that's a rare situation where a dentist is going to run into an emergency. That an additional tooth would need to be extracted in the future is not an emergency. The risks of putting a patient under anesthesia do not trump the consent requirement. Therefore, if you find something else to treat while you are in the middle of a dental procedure, leave it. You need consent to do it. You want to note the jury verdict and the required reading about extracting a wrong tooth. His defense was that it needed to be extracted anyway. He lost. What you need to do is wake the patient up and get consent. If you get into an emergency situation where you don't get consent or treatment is given to preserve life or health during surgery, you want to make sure that good documentation is done. It's going to provide protection later if a claim is filed. Remember, giving treatment without obtaining consent is only going to happen in the rarest of circumstances. All right, let's go on to informed consent. When do you have to get informed consent? Informed consent is not just for invasive procedures or surgery. If there are risks associated with the treatment you're planning, you need to get an informed consent. So, do you need informed consent for teeth whitening? After all, patients do it at home. Sorry, but yes, there are plenty of risks associated with teeth whitening. Sensitivity of the gum tissue, soft tissue irritation, possible sensitivity of teeth to cold temperatures, plenty of things that the patient is going to want to know before they agree for you to do the teeth whitening. The difference is that you're offering the teeth whitening even though the patient could do it at home. So you need to get consent. Proving lack of informed consent takes a lot on behalf of the plaintiff. You might hear a lack of informed consent referred to as negligent non-disclosure. So if I refer to negligent non-disclosure or you read it in a case, it's going to mean the same thing as lack of informed consent. Anyway, it takes a lot to prove it. Lack of informed consent is litigated as a negligence cause of action, and in order to win the lawsuit, the patient will have to prove, 1, that there was a dentist-patient relationship, 2, that the dentist had a duty to know the risk, 3, that the dentist had a duty to disclose the risk, 4, that there was a breach of those duties, 5, that the undisclosed risk materialized in harm and that the patient would not have undergone the procedure if informed of the risk, and 6, damages. Informed consent laws in Minnesota are primarily located in case law. Additional requirements are in Minnesota Statute Section 3100.9600. If you're doing research involving people, you need to follow very specific federal informed consent laws that are in the Code of Federal Regulations. There are also specific informed consent laws for medical devices and investigational drugs, and those are also in 21 CFR. I will be focusing on Minnesota informed consent requirements. If you're practicing in another state, there will be various differences in the wording of the laws, including the way the experts are used in the lawsuit, whether subjective or objective standards are used in proving causation, at what level of invasiveness a duty to discuss risks is triggered, what makes a risk significant enough to discuss, and various other things. As in Minnesota, the law will probably be partially in the state law, in the case law, and partially in the statutory laws and regulations. So you need to know and look in both. So I asked you to read the summaries of the Kohoutek versus Hafner case and the Chrisman versus Davis case. Both cases involve a patient who filed a battery case for lack of consent when it was really a negligence case for lack of informed consent. I'm using the Kohoutek case, even though it involves a C-section, not dentistry, because it is a Minnesota Supreme Court case and states the battery versus lack of informed consent law in Minnesota for any type of medical or dental procedure. The Chrisman case is a Vermont dental case that sets out battery versus lack of informed consent pleading issues in a dental care scenario. These two cases also show the similarities of the consent and informed consent laws among the states and the manner in which the battery versus informed consent legal analysis can be applied to either a medical or dental case. Basically, the law is the same, the facts just change. So in the Kohoutek versus Hafner case, a woman gave informed consent for a C-section, but then she went into labor prior to the scheduled surgery. She was then given Pitocin to add in the progression of labor. She did not refuse the Pitocin, but there was no proof that she affirmatively consented to it. The risks of vaginal delivery were not discussed with her, which was an issue here because she was post-dates and the baby was expected to be large. So labor progressed until the baby's head emerged, but then shoulder dystocia developed and the baby ended up with brain damage. The patient sued for malpractice and battery. Her battery claim was based on not consenting to being injected with Pitocin, which caused her to give birth vaginally. She additionally claimed that she was never informed of the risks of vaginal birth. If you had a chance to read the Minnesota Appellate Court opinion on this case, it was not required, but I put it in Moodle. That court, that first appellate court, focused on the Pitocin injection, which is in fact put in the patient's IV line. So, frankly, it does not look like the patient gave consent to the Pitocin to me. But the Supreme Court instead focuses on the issue of whether she was informed of the risks of a vaginal delivery and seems to accept the patient's failure to refuse the Pitocin as a consent to it. So I don't like the Supreme Court decision in this case, but it doesn't change the fact that the Supreme Court opinion has a great summary of the law on battery and informed consent. All right, the law as stated in Kohoutek. This is what you should focus on in the Kohoutek Supreme Court opinion. 1, that battery consists of an unpermitted touching in the form of a medical procedure or treatment. 2, that touching is permitted if the patient consents to it. 3, consent can be vitiated if the doctor fails to disclose a very material aspect of the nature and character of the touching. So if that's the case, it'll be battery. And 4, consent is not void if the patient is touched in exactly the way to which he or she has consented. According to the Minnesota Supreme Court, Kohoutek's case is not one of battery because her case is really based on the OB's failure to inform her that she could encounter a shoulder dystocia, which she would not if she delivered by C-section. In the court's opinion, she is not claiming she did not give consent to vaginal delivery. They kind of gloss over the lack of consent for the Pitocin injection, and the Supreme Court frames the facts in a way that the Pitocin injection was no big deal because at that point there was no way to tell if the labor would go forward. Once it looked like the patient had a right to decide on a vaginal delivery versus a cesarean section, she had a right to hear the risks and the benefits of the vaginal delivery. She was never informed of the risks of vaginal delivery. And that's true. So she claimed she would have gone with a section if she had known she had an elevated risk of encountering a shoulder dystocia. So in other words, this is an informed consent issue. In the Chrisman v. Davis case, although the facts are really different from Kohoutek, the analysis is fairly similar. In the Chrisman case, the patient consented to a tissue graft but he ended up with a flap procedure, which is a less extensive operation. The dentist did less than he was authorized to do by the patient. The patient consented to the flap because he consented to the tissue graft, is how the court looked at this case. In the Chrisman case, the plaintiff couldn't prove battery, but the court definitely suggested that the plaintiff may have had a lack of informed consent case. Unfortunately for the patient, and fortunately for the dentist, the patient had dismissed the lack of informed consent cause of action from his lawsuit against the dentist. So he didn't really dismiss them. His attorney agreed to dismiss them for some reason. So I think that Chrisman kind of shows you a probable legal malpractice case scenario. All right, now that the issue of consent versus informed consent is settled, we can move on to what it takes for a patient to prove lack of informed consent. In proving lack of informed consent, the patient has to prove that there was a dentist-patient relationship. So we want to figure out first who is responsible for obtaining the informed consent. On the issue of the dentist-patient relationship, only the professional who performs the procedure in question can obtain informed consent for it. So it's not an adequate informed consent if a nurse or medical assistant gives a patient a consent form and discusses the risks, benefits, and alternatives of the procedure, or a student who observes the procedure but doesn't perform it has gone through the consent process, or a patient's treating dentist discusses the benefit and risks of a surgery and then refers the patient to a surgeon. Similarly, dental hygienists have a duty to obtain consent and informed consent for the procedures that they perform, like cleanings and fluoride treatments. So who can give consent? We're still talking about the dentist-patient relationship here. We're looking at the patient now. The person who gives consent is the patient, so long as he or she is competent and has the capacity to consent, or if the patient is not capable of consenting, the patient's representative gives consent for the patient. Competence and capacity to consent are similar but slightly different. Competence is a legal designation that is determined exclusively within the legal system, while decision-making capacity is a clinical concept assessed within the healthcare system. A patient who has decision-making capacity is able to understand the options, able to understand the consequences associated with the options, able to understand the benefits of the options, and able to communicate his or her consent. Examples of conditions that cause temporary or permanent incapacity to consent include mental illness, brain injury, intoxication, or advanced age. Adult incompetent patients may have a healthcare agent, and there are basically two kinds. A power of attorney for healthcare. In other words, the patient has executed a power of attorney for healthcare form that appoints this particular person, or a conservator. A conservator is appointed by the court. Elderly patients, you have to remember, can make healthcare decisions for themselves unless they are not decisional, which is a factual medical determination, or incompetent, which is a decision made by a judge. Minors. As a dentist, you're going to deal with a lot of minor patients. A parent or guardian is a minor's representative for consent because a minor is considered incompetent to consent because of his or her age. The minor laws are not necessarily based on decision-making capacity, but there are exceptions to the minor consent incompetence. So consider this scenario. An unmarried 16-year-old girl comes into your office with her 18-month-old child who has tooth decay. The 16-year-old gives consent to have her child's teeth filled. The next week, after the fillings are done, the young mother mentions that she has a toothache. After examination, it's clear that the tooth has to be extracted. Because she and her child are technically minors, you have to consider competence to get consent and informed consent. So the minor laws in Minnesota are kind of complex. in order to determine whether a minor can consent to dental treatment, you need to know what the minor laws are in the state in which you practice. According to Minnesota law, minors are individuals who are younger than 18 years old. So in the above fact pattern, you're dealing with two minors. The general law on minors in Minnesota is that minors are not legally competent to consent to healthcare services unless specified otherwise in a statute. Consequently, in Minnesota, if there is no statutory exception, then the minor mother would not be able to consent for her or her child's treatment. Therefore, we have to go to the Minnesota statutes to determine whether there is an exception for this minor patient. And there is. According to Minnesota Statute 144.342, a minor who has been married or who has given birth may consent for personal, medical, mental, dental, or other health services or for services for the minor's child. Furthermore, Minnesota Statute 144.341 states a minor who is living apart from his or her parents and is managing his or her own financial affairs may consent for her own dental services. Finally, Minnesota Statute 144.345 states if the minor represents to you that he or she is capable to give effective consent, but really isn't, the consent is effective if you relied upon it in good faith. Exceptions to the minor incompetence rules are based on a minor's capacity to make healthcare decisions, public policy, and common sense. In other words, a 16-year-old mother is capable of weighing the risks and benefits of getting a tooth extracted. Once she gives birth, she kind of passes out of childhood in the healthcare arena. You will note, however, having a child does not change this young mother's status as far as voting, buying alcohol, etc. is concerned. Common sense demands that the young mother be the one to consent to her child's medical care. On the other hand, consider the case in the required reading folder about the 17-year-old who represented to his dentist that he was able to give consent to have 6 gold crowns placed on his front teeth. This is a Florida case, and Florida law is probably different than Minnesota law on this issue of minor consent. There's a possibility that this case would have resolved differently in Minnesota because in Minnesota, once a minor represents that he or she can give consent, the dentist can rely on that in good faith and provide the treatment. So a Minnesota dentist might not win the case against the mother for lack of informed consent, but a Minnesota dentist who accepts a minor's consent for treatment also must accept the risk of non-payment of the dental fees because, according to Minnesota Statute 144.347, if the minor consents to the treatment, it is the minor who is responsible for payment. So you can see how this would be a problem if you obtained consent from a 17-year-old for gold crowns. I mean, would you realistically be able to collect for 6 gold crowns from a 17-year-old? I mean, you wouldn't be able to go after the parents. So there are various different things you want to consider when you're getting consent from a minor. When you're treating the minor, therefore, you need to go through a series of questions before you start the treatment planning. 1, what age is the patient? 2, did the parent consent to treatment? And 3, if not, is there exception? Not obtaining consent for the treatment of children is listed as a, quote, common infraction on the dental board website. That means there are a lot of them. The example given on the dental board website is a patient dropping a child off for a preventative appointment expecting an exam and cleaning. However, the child additionally gets bite wing radiographs, sealants, and fluoride. The parents then complain about this lack of informed consent to the dental board. So you have to be careful about situations like this. The child probably benefited from the treatment, but it was provided without appropriate consent by the child's parents, and that makes it unprofessional conduct and potential malpractice. All right, so tips for creating minor consent policies and procedures. You want to know the state statutes relating to consent for the treatment of minors. You want to know the state legal definition of emancipated or mature minors and include it in your written policies and procedures. You want to create policies and procedures to address evaluation and treatment of minors that are not accompanied by the parent or person legally authorized to consent. For example, a minor who comes directly for school for treatment of acute conditions. It's recommended that the parent is contacted for verbal consent or, if possible, signs a written authorization that consent to that treatment for a certain period of time for a specific diagnosis. You want to develop a written policy and procedure for obtaining informed consent via the telephone as well. Okay, we're back to proving lack of informed consent, and we've talked about the dentist-patient relationship. Now we're going to talk about duties. The dentist has a duty to know the risks at issue. The dentist has a duty to disclose that risk, and the dentist breached those duties. That's what the patient is going to have to prove. Let's talk about those duties. So you're probably wondering which risks need to be disclosed during an informed consent process. In Minnesota, we'll talk first about the duty to know of the risk. The patient must prove that the dentist knew or should have known about the risk. This is proven by expert testimony. It is a standard of care type analysis. If all the other dentists in town knew about this risk and you didn't, you're going to be out of luck. Second is the duty to disclose. Did the dentist have a duty to disclose? If the dentist should have known about the risk, then the patient must prove that there was a duty to disclose it. The test for this is objective, so the patient must prove that an average patient in the same circumstances as the patient would need to know the risk in order to consent. This is an issue decided by the jury. Other states may use various different standards for making the determination of how much information is necessary. Many states require that patients be informed of the significant or material risks. What makes a risk significant or material depends on the circumstances and whether there's state law that provides guidance in that kind of determination. Very few states use a subjective standard. In those states, the physician must disclose facts that that particular patient would consider important in deciding whether or not to submit to a course of treatment or a procedure. And testimony by the patient establishes this. How much information is enough? There are no uniform criteria for determining how much information to disclose to patients. In general, you must discuss the nature of the recommended treatment, the risks, complications, and benefits of that treatment, including the likelihood of success, and alternatives to the recommended treatment, including no treatment at all, with its risks, complications, and benefits. Deciding which risks to disclose is an inexact science. How many do you want to disclose? You may disclose 9 of the 10 risks, and then the 10th will occur with that particular patient. A risk should be disclosed if its occurrence is serious and frequent enough to affect the patient's decision. So basically, you can put yourself in the patient's shoes. Would you like to know about the risks? You could think about the patient as your mother. Would your mother like to know about the risks? It's just important to put a little bit of thought into what you're doing with the informed consent process. Serious risks should be disclosed even if they infrequently occur. So for example, death from anesthesia. The Minnesota Board of Dentistry wants you to discuss the probable cost of the treatment, but this is not required pursuant to the informed consent case law in Minnesota. If you're performing an elective procedure, you want to expand your discussion of risks and benefits because patients undergoing elective procedures frequently have higher expectations and frequently unrealistic expectations of the outcome of the procedure. All right, back to the proving of the lack of informed consent. If it's a case of lack of informed consent, the plaintiff must also prove causation. In the causation analysis, the patient has to prove that the undisclosed risk materialized in harm. So, did the lack of informed consent cause the patient's harm? There's a two-pronged burden that the patient has to meet in order to answer this question. This is one of the issues that makes it very, very difficult for a plaintiff to win an informed consent case. First, the patient has to prove that he or she would not have undergone the procedure if he or she had known of the risks of the alternative treatment. Also, the patient has to prove that the undisclosed risk materialized in harm. To determine the first aspect, the court uses an objective standard. In other words, would a reasonable person in the plaintiff's position have refused the treatment had he been informed of the undisclosed risk? So, applying this test to the Crispin case, the jury would consider whether a reasonable person who was being treated for gum recession and root exposure would have undergone a tissue graft procedure if he had known that the dentist may intraoperatively decide that a flap procedure is the appropriate course and that not all flap procedures succeed and may result in a later graft being necessitated. Maybe. I think yes. Did the undisclosed risk materialize in harm? Looking at the Crispin case again, the answer there would also most likely be yes. The flap procedure failed and a subsequent tissue graft was necessary. The issue of harm needs to be established by expert testimony. Here again is the citation and a reminder about informed consent for medical research. Informed refusal. Patients also have a right to refuse dental treatment. If a patient refuses your recommended treatment, you have the right to withdraw from the treatment of that patient. Sometimes you're going to have to. If another healthcare provider is willing to comply with the patient's wishes, transfer that patient as soon as possible and practicable. When the patient refuses treatment, you need to inform the patient of the potential consequences of refusing the treatment. So, for example, a patient who refuses a recommendation to extract a completely bony impacted third molar must understand the potential for continued symptoms, bone loss, and serious, potentially life-threatening infection. Consider, however, that a patient's refusal for treatment will not excuse a dentist's failure to provide treatment that meets the standard of care. So, for example, if a patient's refusal to have diagnostic radiographs before treatment would result in substandard care, you cannot go forward with the treatment without the radiographs because it's below the standard of care. Communication is the key to informed consent. All essential information must be communicated so the patient understands it. This requires assessing the patient's level of overall literacy, including health literacy. So, for example, an elderly woman who speaks little English comes in for some extractions. The risks and benefits are listed off to her in English, and she is then asked to sign a consent form in English. When asked if she has any questions, she says no. The chart states risks and benefits of procedure explained to patient. No questions. However, this patient suffers severe nerve damage, which leaves the left side of her face numb, a permanent droop on the left side of her mouth, and difficulty speaking. If a lawsuit results and lack of informed consent is alleged, the dentist will not be able to successfully put forward a defense that the risks and benefits were explained because it is clear that the patient could not possibly have understood them. So even when you are not required by statute to provide a non-English speaker with an interpreter, you can still be sued for lack of informed consent. The Americans with Disabilities Act additionally requires that you be able to communicate with the hearing impaired at the same level as you communicate with a hearing individual. If the person needs a sign language interpreter, you have to provide and pay for it. Foreign language interpreters are required if you accept Medicaid patients. Foreign language interpreter services are a covered benefit for Minnesota Care Program's fee-for-service recipients on medical assistance. Recipients of all three major programs in Minnesota that are enrolled through a prepaid health plan are covered for interpreter services. So if somebody needs an interpreter, contact the prepaid health plans for billing information. Recognize when a patient is not taking part in the consent process and find some person to help you make the consent for treatment an informed one. Now, moving on to health literacy and what people actually understand of the informed consent process, even if their literacy is okay. I had you read an article entitled Informed Consent, Optimism versus Reality. Even though this is a British article and we all know about the British and their teeth, the informed consent recommendations are consistent with the general U.S. standards. So don't discount the case study because it was done with the British. So this study in the article indicated that only 40% of the patients signing informed consent forms for their children's treatment understood the procedure described to them to a degree necessary to give an informed consent. Other studies have shown that patients retain only about 30% of the verbal information they get during the consent process. In the study, the percentage of those understanding the procedure increased when they got the same information a second time at a later date. It is smart to supplement informed consent discussions with audiovisual and written handouts that inform patients about the proposed procedure or treatment. When materials are provided in advance, patients have time to process the information and formulate questions before giving consent. Should a lack of informed consent claim arise, proof that the patient had an opportunity to review educational materials will bolster the defense of the claim. You want to try something like the teach-back method to make sure that the patients are getting what you're telling them. So for example, ask something like, just so we're on the same page, can you tell me some of the unexpected things that could occur as a result of the extraction? You want to always use layperson's terms. Documenting informed consent. Informed consent involves discussions with your patient. It is a process of education. In the end, the patient should understand the facts and your opinions. From those facts and opinions, he or she should be able to decide what to allow. Use the informed consent discussions to set realistic patient expectations for treatment outcomes. Think of informed consent as a rapport building tool. So building rapport and educating patients really has little to do with documentation. So why should you document? Because it's proof of what you did. And it's also required by the Minnesota Dental Board. The Dental Board informed consent documentation requirement is in 3100.9600 of the Minnesota State Regulations. That regulation requires that A, the dentist discussed with the patient the treatment of options and the prognosis benefits and risks of each, and B, that the patient consented to the treatment chosen. The Dental Board also recommends informed consent to include the cost of treatment. As I said, this is not a malpractice issue. However, a patient who feels that he or she has been misled in a cost estimate is going to be angry, and angry patients are more likely to sue for malpractice. So there's a little bit of a cause and effect issue with the cost, bringing up the costs. Consent forms. Consent forms have lots of benefits. There is an example of a consent form in the Moodle resources folder for today from TDIC. Most insurers will give you a consent form that you can use and change to fit your purposes. Forms can augment the consent process in a number of ways. You can use the informed consent form as a checklist, and it can keep you on track in covering information during the informed consent discussions. When a copy of your informed consent form is given to the patient, it reminds the patient of what's been covered. A lot of patients during the informed consent discussions are too overwhelmed to fully grasp what's happening. So forms will reinforce what you've noted in the records regarding these consent discussions if the patient forgets. You want to make the most of your consent documentation. I know that it takes some time. So you want to write up the informed consent in layperson's terms. That's at a 6th grade level. Courts have found that 2 technical forms are invalid. You want to have the patient sign and date the consent form. You want to give the patient a copy to bring home. You want to note in the chart what was discussed, that the consent form was presented, and that it was signed, and that the patient got a copy to bring home. If you note that a copy went home with the patient, it's going to be very difficult for the patient to convincingly argue that they were not aware of the risks. You also want to allow space in your form to add additional risks, benefits, and alternatives that may exist due to the particular patient's condition. Studies have shown that patients who feel that they are integral partners in their healthcare treatment experience better outcomes and have increased satisfaction with their healthcare provider. So happy patients equals fewer lawsuits. Thank you very much.